Good morning, everyone. I'd like to thank you for joining us today. Welcome to our webinar. This is part one of our series of webinars on commercial agency law for principals. My name is Suzanne Carr. I'm one of the senior associates in the dispute resolution team at Meyerson, and I'm joined today by Robert Brothers, who is an associate in my team. Robert and I are both part of a team of lawyers who specialise in commercial agency law as part of our wider dispute resolution practice. So the purpose of today's webinar is to provide businesses with an overview of the commercial agents regulations. And what we'd like to do is to try to help you to identify if you may have a commercial agent working on your behalf, and to understand the rights and obligations of both the agent and principal if the regulations do apply. So we'll briefly have a look at the following topics: an introduction to the regulations, looking at whether you employ a commercial agent, then moving on to the rights of an agent and the rights of a principal. And then we'll have a look at whether a principal can contract out of the regulations, whether a principal can vary the agency contract, and then finally some top tips for principals, including what to do if an agent is not performing satisfactorily. If there are any questions that you have and you'd like to be answered following this webinar, which may be more specific to you or your business, and you would like to discuss them with one of the team, then please do contact us separately and we'd be more than happy to chat through your query. So by way of a brief introduction to the regulations, they enact a piece of EU legislation, which is an EU directive on commercial agency law, and they enact that directive into English law. There is some history behind the regulations, which isn't especially interesting, but just briefly, in the 1970s, France and Germany had well-established laws which protected commercial agents. And those laws were similar to the rights afforded to employees. And those countries wanted to codify those protections across the EU. So after much consultation, the EU directive was passed in 1986. And the idea behind it was to harmonise legislation of EU member states in relation to the treatment of independent commercial agents. And by way of the EU directive, Britain was required to implement that into its national law, and it did that eventually in 1993, giving rise to the Commercial Agents Council Directive Regulations 1993. What is strange about the regulations are that many of the features are alien to the English legal system. They impose obligations on principals that would not otherwise feature in English contract law. And what is important to grasp is that the regulations impose mandatory rights, which provide a whole raft of protections to agents, such as the right to minimum periods of notice and right to compensation and the right to an indemnity on termination of the agency. They somewhat limit the freedom of the parties to contract, which is thought by many to be a cornerstone of the English legal system. And I should add that the regulations are a piece of legislation which are unaffected following Brexit, and that is because they have been adopted as retained EU law. So the important part, helping you to identify, do you employ a commercial agent? And this moves on to the practical application of the regulations. And it's our experience that there are many businesses who are either unaware of the existence or effect of the regulations, or maybe just don't appreciate that someone who is selling goods on their behalf is classified as a commercial agent and is therefore afforded the protection of the regulations. So what makes someone a commercial agent? Well, the regulations do contain a definition of a commercial agent, and it's slightly long-winded, and I've not included it on the slide, but it reads as follows. So it's a self-employed intermediary who has continuing authority to negotiate the sale or purchase of goods on behalf of another person, the principal, or to negotiate and conclude the sale or purchase of goods on behalf of and in the name of that principal. So we can break that definition down and put it in more simple terms. So a commercial agent must be the following. They must critically be independent of the principal. They can't be an employee or a partner or an associated company. So autonomy and independence is absolutely crucial. Secondly, the agent must be authorised to approach customers and market the principal's goods. And they must have the continuing authority to do that. And finally, the agent must be paid. And that can be either by way of commission, which is usually as a percentage of the value of goods sold, or it can be by way of a fixed retainer, or sometimes a mixture of both. So somebody who's volunteering to sell products and isn't working on a paid basis wouldn't be a commercial agent. We are often asked the question, does there need to be a written contract? And the answer is simply no. There will often be no written contract in place, but that isn't going to affect whether somebody is a commercial agent or not. If the agent performs the functions of an agent and meets the definition that I've just talked about, then they will enjoy the protection that the regulations offer. It is sometimes the case that an agent will perform some non-agency tasks, but provided they remain independent of the principal, that isn't going to be fatal to them being a commercial agent. So coming on to the requirement that the agent must sell goods, it must be a sale of goods as opposed to services. And usually that is a straightforward issue to determine. And goods are usually tangible items. For example, the sale of shoes would be goods, whereas the sale of insurance would be a service. But what is interesting and peculiar is that the regulations don't contain a definition of goods. So that leaves uncertainty as to whether some products are classified as goods or services, especially where the product is in an intangible form. For example, software, which is downloaded by the end user. Fortunately, the courts have stepped in to provide some clarification in this area. So for example, gas and electricity can be classified as goods, whereas the sale of a digital package of, say, Sky Television is not going to be classed as goods. There is a question over software, but we have recently been given clarification from the courts about this. And software provided electronically is now capable of being goods, but only in certain circumstances. So that's only currently where the software is provided under a perpetual license. The meaning of negotiate and continuing authority to negotiate, which are both phrases in the definition I read earlier, are interpreted very widely. So that will include an agent who simply introduces customers to the principal. And as a rule of thumb, it's not necessary for agents to individually negotiate the terms or the sale or the prices of products. What is required is that the agent goes out and develops goodwill for the principal by approaching customers and marketing the principal's products. And finally, for the regulations to apply, the agent's sales activities must take place in Great Britain. If they are operating outside of Great Britain, then the regulations are unlikely to apply, unless, that is, that the parties have agreed that the regulations will govern the agency relationship. An agent can be an individual or a limited company. And subagents, this is something we are regularly asked about. They are in a different position to the main agent. They are contractors of the main agent who are hired to help sell the products of the principal. The key difference here between a main agent and a subagent is that the subagent's relationship, the contractual relationship, is not with the principal. And because of that, whilst technically doing the same job as the main agent, the subagent is not going to be given the protection of the regulations. In practice, what that means is that in the event that the subagency is terminated, the subagent will not be entitled to claim a termination payment under the regulations. There is a key difference between distributors and agents, and I'll just touch on that briefly. So the key difference is that an agent will contract with the end customer in the name of the principal, not in its own name. Whereas a distributor or reseller of goods will sell goods in its own right. So its contract with the customer will be in its own name. And the regulations will not apply to distributors or to resellers. So what rights does an agent have? Well, there are a whole abundance of rights given to commercial agents. I've listed the relevant parts of the regulations on the slide for reference, and I'll look at some of those in a little more detail. So firstly, an agent has the right to documents and information from the principal, and that includes the right to be given a written agency contract if the agent asks for one. And this is often a right which is overlooked by agents where they are not initially given a written contract. They will have the right to information about sales made to customers by the principal, where the agent is entitled to commission on those sales. They have the right to receive regular commission statements. And if the agent is paid by way of commission on sales, then the agent is entitled to be paid commission on sales to customers during the life of the agency where either of the following apply. So either where the order is from a customer that the agent has introduced, or the order is from a customer within the agent's exclusive territory. And in that latter category, it may well be that the customer hasn't been instrumental in getting an order in, but if the order is from a customer within the agent's territory, then they are going to be entitled to commission on that sale in any event. If an order is not fulfilled due to the fault of the principal, which can happen regularly, then the agent will still remain entitled to be paid commission. It's only where an order is not fulfilled and that isn't due to the fault of the principal where the entitlement to commission will fall away. And then the agent has an entitlement to commission on sales after the agency is terminated. This is under Regulation 8. This is an entitlement to sales for a reasonable period following termination, but only where the sales can be said to be mainly attributable to the agent's efforts whilst he was an agent. And these are commonly referred to as pipeline commissions. The most significant right for an agent in most cases will be the right to compensation or an indemnity payment following termination of the agency. And that right will arise in the following circumstances. Either where the principal has terminated the agency due to no fault of the agent, or where the agent terminates the agency himself or herself because of a fundamental breach by the principal, or if the agent retires due to age or illness. And that is something that we will look at in a later webinar. And finally, the agent is entitled to statutory notice of up to 3 months, where the notice must end at the end of a calendar month. In addition to all of these rights, the principal must act dutifully and in good faith towards the agent. This duty was imposed by the regulations in order to regulate how principals behave towards their agents, and is very much focused on affording the agent protection from unscrupulous behaviour by the principal. So the agent can expect his principal to abide by this duty and act in good faith. And it's really important that principals are alive to this duty of good faith when dealing with agents. It's a duty which can very easily be breached. And if it is, it would give the agent a basis on which to assert a breach of contract, and that is to be avoided. If a principal does act poorly towards the agent, then it could be found to be in breach of the duty of good faith and in breach of the regulations. And as I say, this is something which should be avoided, as it could mean that the principal is liable to the agent for a claim in damages. And indeed, if the breach is serious enough, the conduct of the principal may entitle the agent to bring the agency to an end, to terminate the agency himself, and would still give rise then to a right for the agent to claim post-termination payments. As I say, we are proposing to do a further webinar which will focus on the sort of conduct which might give rise to the right of an agent to terminate on the grounds of such fundamental breach. It's a topic which we could spend a whole webinar on, and so we will look at that at a future date. I will now hand you over to Robert, who's going to look at the rights of a principal, and we'll finish the webinar. Thanks, Rob.
Thanks, Suzanne. Morning, everyone. By way of reminder, my section of the webinar will cover principals' rights under the regulations, contractual considerations such as contracting out of the regulations and varying the agency contract. And finally, I'll provide some of our top tips for principals. So I will begin with what rights do principals have? And I am just going to get onto the correct slide. Here we go. Okay, principals do have rights under the regulations, and these are analogous to the good faith duties which Suzanne's just run through. The regulations impose an obligation of good faith upon a commercial agent towards their principal, which means that when an agent's performing the agency, they must look after the interests of the principal, act dutifully and in good faith, make proper efforts to negotiate and conclude transactions that they're charged to take care of, communicate all necessary information to the principal, and comply with reasonable instructions given by the principal. And these obligations are imposed by the regulations. However, the principal can also agree additional obligations with the agent in order to help regulate the agent's performance, such as agreeing sales targets and attendance at weekly or monthly sales meetings, for example. So another consideration is, can a principal contract out of the regulations? Firstly, just to explain, what I mean by contracting out is the inclusion of a term in the agency agreement that expressly excludes the regulations or a specific provision of them. However, one thing to keep in mind is that some of the regulations are mandatory, which means that the principal can't try to override these or exclude their application, even with the agent's agreement in some circumstances. There's express wording in certain regulations that say they can't be contracted out of. So, for example, if a principal was to try and limit the minimum notice period that they have to give to an agent to say 1 week, then that would be a clear derogation from the statutory minimum notice requirements provided by the regulations, and this term would be void if included in a contract. The regulations also say that the parties can't agree to disapply post-termination compensation or indemnity payments, otherwise known as Regulation 17 payments, which Suzanne has mentioned earlier. Therefore, any contractual term which says that an agent is not entitled to these payments is null and void. However, there is some uncertainty in respect of certain sections of the regulations where these don't contain express wording that prevents the parties from contracting out. So take, for example, Regulation 8, which concerns an agent's entitlement to post-termination commission for a reasonable period of time. More commonly, this is referred to as pipeline commission, relating to orders that conclude after termination of the agency. So Regulation 8 actually contains no wording to prevent it from being contracted out. Therefore, a principal could legitimately question whether an agent's entitlement to pipeline commission could be excluded in an agency contract. And indeed, this is a question which has caused much debate among practitioners. In fact, many agency agreements have clauses that will try to exclude pipeline commission on orders that come in after the agency terminates, even where those orders are likely to be attributable to the agent's performance during the agency. So just to conclude on this point, whether or not pipeline commission can be excluded by an agency contract hasn't actually been formally considered by the courts. There's no express non-derogation provision in the regulations concerning this type of commission. So technically the parties could agree to exclude it in the agency contract. However, I would question whether this exclusion would be at odds with the overriding purpose of the regulations, which is to protect an agent. So in keeping with contractual considerations for a moment, we now ask, can a principal vary the agency contract? So as a principal's business develops, then so do its needs. For example, a principal might want to improve its margins by reducing commission rates or changing its product lines or amending territories covered by the agent. The effect of that is that the principal will likely want to agree different terms with the agent, being terms that are different from those originally agreed at the start of the agency. So a change to the terms can be agreed orally or in writing with the agent. However, the principal should be mindful of existing written contracts, which might actually set out how terms may be varied. For example, many contracts state that variations are only effective when recorded in writing and signed by both the parties to the contract. In any case, when dealing with variations to contractual terms, it's generally best practice to record all agreements, consents, and changes in writing with the agent, and that avoids any challenges in the future. Now, what about unilateral variations? So those are variations imposed on the agent without their express agreement. Would such a variation be legally binding? The answer here depends upon the agent's conduct after the agent receives notice of the variation from its principal. So if the principal tells an agent that things will be a certain way from now on, so for example, commission rates will be 5% instead of 10% on sales, and the agent objects or demonstrates that they're not accepting this change, then that change is unlikely to be legally binding on the agent. And furthermore, the principal might be liable for a damages claim if that variation already took effect. So you have to be very careful when trying to impose variations unilaterally. On the other hand, if the agent simply does nothing when given notice of the change and continues with the agency without raising an objection to the very term, then that agent may be deemed to have accepted the change by their own conduct and then can't challenge it further down the line. So just to wrap up this point, there may be circumstances where a principal, for whatever reason, wants to change the agency terms, but it's always advisable for a principal to seek legal advice before trying to vary the agency contract, and that just ensures that the principal's position isn't prejudiced in any way. So finally, I'm going to conclude with our top tips for principals. These are by no means exhaustive, but hopefully they should be helpful. And there is, of course, an opportunity to ask us any questions at the end of the webinar. So in summary, our top tips for principals are identify whether you have any commercial agents working for you. You may need to conduct an internal audit of your business or seek legal advice to determine the answer to that question, but it's certainly a worthwhile exercise and can avoid some nasty surprises in the future, especially whenever it comes to terminating the contract of the agent. Find out whether there's a written agency contract. If there is, just make sure you're familiar with its terms and what the parties' obligations are. Before varying the contract, consider whether there are any terms in the contract which specify any circumstances where the parties can vary the contractual terms, and importantly, how to go about doing that, including any contractual formalities that need to be followed. Record any variations to the agency contract in writing and obtain the agent's agreement to any variation beforehand. And that usually avoids problems later down the line. And if the variation is likely to lead to a dispute with the agent, then do seek legal advice. It's always better to understand the various rights and obligations under the agency contract and under the regulations before any significant changes are proposed. And finally, I'll just wrap up with some practical advice on what to do if there are concerns about an agent's performance. So it often happens that that a principal will have an agent that isn't meeting expectations. Perhaps their sales are lagging, or the agent's not making regular calls on customers. The agent's refusing to comply with reasonable requests, such as regular reporting, or perhaps using a new piece of software the principal is rolling out to promote products. And also a very common reason for principals terminating their agents is due to sales targets not being met. And those sales targets are often integrated within the agent's contract itself. I would say, however, frustratingly for principals, an agent not meeting contractual sales targets is probably unlikely to amount to a serious breach that would entitle the principal to terminate the agency agreement for poor performance. And that's also the case for relatively minor breaches by the agent that would not, in legal terms, be considered sufficiently serious to justify terminating the agency. So it's important in circumstances where a principal is concerned about an agent's performance that they seek advice on the appropriate steps that can be taken to address that performance without prejudicing the principal's position. So all that being said, it's still important to remember that the agent owes a duty of good faith and cooperation towards his or her principal, and a duty to comply with reasonable requests for information. So if an agent is being obstinate or uncooperative, then that could amount to a breach of the regulations or contract and can potentially amount to a serious breach, justifying termination of the agency. And even if a breach is relatively minor, for example, if an agent keeps failing to return calls from customers or missing important sales meetings, then a repetition of this conduct over a period of time could add up to a serious breach. So my final top tip for the day is for principals where an agent isn't performing is to keep a good record of the conduct complained of, identify what the concerns are and how that conduct is affecting the principal's business. Keeping a bank of evidence such as this can really help a principal if an eventual termination event of an agency is challenged by the agent. And finally, if there are serious concerns, then we would recommend any principal in that situation to seek legal advice on the options available. So that brings us to the end of the presentation section of the webinar. We hope you find it useful. That just leaves the questions and answers section. So if you haven't done already, please would you populate your questions within the Q&A tab, and we'll try and answer as many as we can. And just finally, as a reminder, this webinar is recorded and will also be circulated later today. So we're just going to take 30 seconds to read the questions, so just bear with us.
Thanks, Rob. So we've a couple of questions. So the first question is, is an agent selling a mixture of goods and services protected by the regulations? This is a question which like many issues under the regulations is going to be determined on a case-by-case basis. The fact that an agent is selling a mixture of goods and services isn't necessarily going to be fatal to them having the protection of the regulations. The question is whether the sale of goods is the dominant purpose of the agent's business, or whether it's ancillary to the agent selling the services. If it is the dominant purpose, if you like, then the agent is likely to be protected by the regulations. And likewise, if the goods are ancillary to the services, then it's likely that the agent won't have the protection of the regulations. What is important to note here is that it's an all or nothing. So it's not going to be the case that the regulations will apply to part of the agent's contract, the part where he's selling goods, and not to the part selling services. It's that the regulations are going to either apply to the whole of the agent's contract or not at all. Rob, do you want to move on to one of the following questions?
Yeah, I see there's a question there from Albert there, and he says our biggest concern is the agent leaving and taking clients, and how do we protect against this? It's a good question, and obviously Suzanne, feel free to jump in if I've missed anything. But I think the main protection that you could have is contractual. You could integrate a restrictive covenant clause within the agent's contract, which says that the agent can't compete in the same market, say for a period of time following termination of the agency, or can't solicit business or customers that they've been dealing with. The difficulty with these types of clauses is enforceability. It could be, well, it would most certainly be classed as a restraint of trade, which could be subject to challenge if the principal did try and enforce it against the agent. I would also query whether there's any possible recourse to claim misuse of confidential information or trade secrets, say if the agent's taken customer lists or customer data and has taken it away, perhaps maybe to start up himself or with a new principal. There are certain steps, perhaps maybe injunctive relief measures that you could possibly take to prevent that. So Suzanne, do you want to have a look and see if there's the next one? But thanks for the question, Albert.
So question from Paul is, when sales involve ongoing relationships where renewal fees would accrue, are the agents still entitled to commission post termination? And I think so I have to make some assumptions here when answering this question. If the renewal fees themselves aren't going to change the agent's rights, the renewal fees, if the agent is entitled to a commission in respect of those renewal fees, then I don't see any reason why if there are going to be renewal fees after termination, that the agent wouldn't be entitled to commission on those fees, provided they fall within the reasonable period after termination under Regulation 8. If it's the case that the agent is never entitled to commission on the renewal fee, then I don't think the agent would be entitled to be paid commission on that fee post termination. I hope I've read that correctly. I hope I've answered that question fully. But if not, and Paul, if you'd like to talk through that any further, please do get in touch after the webinar. Rob, do you want to take the next one?
Yeah, there's a question there from an anonymous attendee. So it says, if in the future we decide to withdraw from a market and thus do not need the services of an agent at all, are we liable for any exit costs, or does the commission merely decline as sales drop? Again, it's a great question. My view is that if a principal takes the commercial business decision to withdraw from a market, and there's a commercial justification for doing so, then I don't think that there would be an exit cost associated with that. And I think you are correct that commissions would just consequentially drop because sales are also dropping. But I wouldn't view that as any sort of, I wouldn't view that as a variation of the agent's agreement by the principals, just more of a consequence of how the principal is operating its business moving forward. I don't know whether you'd agree with that, Suzanne.
Yes, I do agree with that, Rob, and I think it's not going to change the principal's liability from a legal point of view, but what obviously it does change is it potentially changes the value of that agency business. If the agent were to be terminated, for example, if the principal has withdrawn from the market and the levels of commissions have significantly dropped, then clearly the value of that agency business is no longer going to be what it used to be, and therefore any
Oh, I think we may have lost Suzanne. There's one more question on there, which I'll answer, and then I think we can conclude the webinar. But you can of course email us separately if you know, at the end of the webinar, and you've got our details there on the slide. So I'm just going to read this last question here. We have agents who are paid via commission, whether they generate the order or it's sent direct to the office by the customer, as well as independent accounts on the agent's area. We also have group accounts where the sale is listing is done by an employed national account manager. Once the deal has been done, the listing is sent to the agents who take orders from the local store. We then pay commission on those orders. However, sometimes promotions and listings are generated purely by the national account manager and are delivered to the store with no involvement of the agent. We do not pay commission on these allocations, but do pay commission on top of orders taken by the agent. Is that correct? It's probably a question that requires more looking into. On the surface, I would say that it looks as if you've got an exclusivity arrangement with the agent, whereby the agent generates orders that come into the that are placed come what may. But for these orders that come in via the national account manager, now if the agent has been operating like this for some time and hasn't raised any queries, so let's say the agent knows that it's not paid commission on some orders and it accepts that, then I don't really see that there's an issue with that. But again, it might be just a question that we would have to look into further. And yes, please feel free to contact us direct if you need to speak to us and run more details by us. So I think that we've answered most if not all of the questions in the questions and answer section. That just leaves me to wrap up the webinar and say thank you for everybody that's attended, and thanks for everyone that's asked any questions. Our details are on the last slide here, so please feel free to contact us if you've any questions about the presentation or commercial agency law in general, and we'd be happy to help. Thank you.